Welcome back to the show. Today we have the legendary Scott Wilson. Scott, how you doing today?
I'm doing good, Jeremiah. How about you?
I'm doing good. You've been doing law for quite some time now.
I would say that's correct. Since 1975.
Since 1975. What got you into, what made you want to go to law school?
Well, to be honest, we were talking about Crawford High School, where I went to high school. It came out in 1967. I had a civics teacher then, Mr. Murphy, and he told me that it might be something I'd be interested in. And so when I went to undergrad school, I looked into it a little more, and I just kept pursuing it.
Right, man, 1975. Has law changed at all since then?
Yes, laws changed significantly since then. In terms, I specialize in employment law, representing employers in labor and employment law. So that area of practice has expanded considerably since 1975. And then the types of cases, the technology, it's an entire new world than from when I came out of law school in 1975.
And you started in agriculture employment, right?
Well, it's kind of a long story. So do you mind if I tell the story?
Please do.
Okay. So when I was in law school and I went to USD, this area of law was just called labor law. And it primarily dealt with union management relations. And so I got a job. My first job was out in Imperial Valley soon after law school. And that involved a labor dispute between the agricultural employers, the growers, and then Cesar Chavez, who was organizing the farm workers. I represented the employers, yeah. So anyway, so as a result of that, I stayed in this area. I was in Imperial Valley, came back here about 1979, eventually joined a really large management side labor firm that represents employers, and I opened their office here in San Diego. And so I stayed with them for about 24 years. 1980, I left that firm and then went on my own. Now I have my own practice, still doing the same thing.
Wow. So how has employment law changed since when you first started in 1975, you're essentially fighting the unions, for the employers, and then you switched over to fighting for the employee?
No.
Always stayed fighting for the employer?
No, I always represented the bad guys. No. And so first, let me correct you there. We weren't fighting the union. We were advising the employers as to what their rights were in response to union organizing. Okay, and so, and then as time went on, the practice that I refer to as labor law when I came out of law school expanded beyond just union management work into, to employment discrimination cases, wage and hour cases, wrongful termination cases. So it's a much broader area of law. You'd ask how it changed over the almost 50 years because the types of cases have much broader area of practice now than when I first came out of law school.
When you first came out of law school, and was there a big, because now you have like the Me Too movement, a lot of sexual harassment cases, a lot of racial discrimination cases now. Was that a thing back in the 70s and 80s?
Well, no one had heard of sexual harassment in 1975, and not that didn't expand significantly. Now, with race discrimination, there was a federal civil rights law, Title VII referred to, that was passed in 1964. So discrimination law, particularly racial discrimination law, was an issue back in 75. Now, as far as the gender discrimination, sex harassment, and all that, That came about more in the late 80s and in the 90s. And then since then, obviously, that's a major area of law that in terms of the types of cases that employers, have to face.
Right. So when you first came out, like, what was you were fighting over? Were you mainly fighting for like wages or working conditions?
Well, I wasn't.
Not,
like I said, I was
you're representing the
employer.
employer. Well, I mean, were they fighting? Were the people? Sorry, the employees you're representing, the people who were going after them, were they fighting more for wages and
It gradually
conditions?
expanded.
And they gradually
So when I
expanded.
first came out of law school, it was mostly union management. And then as time went on, we got into more of the employment discrimination, the wage and hour claims, the sex harassment claims, the age claims, retaliation claims. That's more of what this area of practice is today.
And have you if you can name them, who are some of the employers you've represented?
I can't.
You can't. It's totally fine. You don't have to
No.
disclose that. So, where do you see employment law going in the future? It's changed so much in the last 50 years. How much more do you see it changing in the next 50 years?
Well, it's really interesting because the workforce has changed so much. And so now the next group of college graduates, I think it will be referred to as Generation Z. Well, okay, so that's a whole brand new genre or group of workers with different views of society than I certainly had in 1975. And so I think it's changing in terms of the lifestyle and the culture of the emerging workforce. And it's just a far different group, much more technologically savvy, different cultural values, look at things in different ways. And I think that their culture and that emergence of that group of workers then will spill into the workforce, and employers will have to respond to that and adjust to the new types of employees that are coming in.
Do you think so? It's not easy starting a business. Most people start their businesses from scratch and they grow it accordingly, right?
Correct.
And now you have what's supposed to be private, and America is supposed to be about you starting a business, you doing things privatized and all that. And now they're trying to force sort of new things that sort of seem trivial onto the employers now. Like you have to hire an array of employees. You can't just hire who you want to hire. You have to hire X, Y, and Z, or else you get sued.
No. I think, and a lot of this is particular to California. Not many states have an employee environment like you do in California. If you got in your car, drove over to Yuma, Arizona, and you were dealing with the laws in Yuma, that's a whole different world than what you're dealing with in California. So a lot of the things you're saying are unique to California, more so than any other state in the country. So when I was with the really big law firm, a lot of our clients, and that law firm was nationwide, a lot of our clients were based in other states. And then when they would operate in California, it was an entirely different set of rules that they had to deal with. So yes, California is a very difficult environment for an employer, without question.
And you help navigate them on
Yes.
the rules. Like, hey, you're coming into California territory. If you want this California money, you're going to have to abide by these
Right,
rules.
and that was our joke when you cross the Colorado River to come into California. You're going to be dealing with, a whole different set of workplace obligations that you don't face in these other states. And that was kind of a culture shock for a number of them. And it created, for a lot of companies, very significant employer liability, particularly wage and hour cases, where there are certain pay rules in California that you don't have. Most states, in terms of paying their employees, abide by a federal law known as the Fair Labor Standards Act. California has the California Labor Code and has much higher standards in terms of workplace compensation. So employers, when they would come here, would operate as they were covered by the FLSA, not the California Labor Code. And then there were a number of lawsuits that arose from that.
Wow. Can you expand on that a little bit? Like,
Sure.
so
Okay, I'll give you an example.
give me an example, please.
Okay, so let's talk about paying overtime to your employees. Under the Fair Labor Standards Act, you only have to pay the employees over 40 hours in a week. In California, you have to pay them over 8 hours in a day or 40 hours in a week. So under the Fair Labor Standards Act, in theory, you could work the employees, say, 3 12-hour days, and you wouldn't owe any overtime because you only had 36 hours. In California, you would owe 12 hours of overtime because you had 12, 3 times 4 over the 8-hour days. And so that's an example right there.
Is there some other California specific laws that other employers, other businesses should be aware about before they come to California doing business?
The wage and hour laws in particular are the most difficult because the way the labor code is written, it's very, very complicated. It can be very complicated for employers to comply with. And so if I were coming here, that's what I would look at. The closest would be the obligations regarding pay practices. Because if you violate the California Labor Code, then you're subject to lawsuits. And the lawsuits not only subject you to any out-of-pocket losses the employees have, but then there's liquidated damages and attorney's fees. And so very, very expensive process, very difficult statute for employers to comply with, not only those who have always been in California, but those who are coming in from other states.
Is there any laws that you believe, maybe personally, that are just like ridiculous? Like it's such a low bar, low hanging fruit for an employee to sue you, that it's sort of like ridiculous that maybe employers should know about so they can like veer away from it?
I think the California Labor Code and the wage and hour obligations, I mean, if you make like a de minimis mistake on someone's check, you don't properly list the name of the employer, there's a $4,000 penalty for that.
Oh my God.
If someone misses a meal or a lunch break, and they're supposed to have a duty-free lunch break, say 30 minutes, if they don't get that, you owe them an hour's pay. So let's say, okay, you should give them the hour's pay. But then if you didn't give them the hour's pay, then the argument is when they leave, well, their paycheck was inaccurate because it didn't show the hour's pay. They weren't given all the money they were entitled to in theory, so they get 30 days more pay on top of that. So you can turn just de minimis mistakes into multi-million-dollar lawsuits. And I think that's the biggest problem facing California employers are these wage and hour laws.
What's keeping companies in California when it's sort of like so expensive? Like you hear it all the time. And I'm not just speaking about big corporations. I'm talking about the little guy, the small businesses who just cannot keep up with California it's almost like California doesn't want small businesses to thrive in California.
I agree, but I don't want to sound partisan. I think it's a very difficult state to do business in, and that's why more and more people are leaving California. I mean, there's a net exodus of people that live here, and because, like I say, you go to other states, you simply don't have this business environment and you have a labor code that's written for plaintiff lawyers to sue you, and it's very difficult to comply with.
Man, California makes it very hard. Even big corporations are leaving California, right? Well, Tesla left, and I believe they might be coming back. I'm not sure.
Tesla is a good example. Elon Musk cited when he left that he left because of, the business climate here. And I, being someone who represents employers and have for going on 50 years, I mean, it's changed tremendously, and I think he's right.
Do you think California will ever change? Because, I mean, they have to. If they're losing all that tax revenue, they have to eventually realize, hey, we're hurting businesses. Businesses don't want to do business in California anymore. They're going to Texas. They're going elsewhere. They're going to Idaho. We should probably change some of these laws. We overcorrected. We wanted to look out for the employee. Maybe we a little bit overcorrected to the point where it's so easy to sue the employer now for the slightest infraction.
Let me give you an example, and hopefully history will repeat itself. So in the 1970s, there was a proposition passed, Prop 13, and it limited property taxes. And the reason that came about is the property taxes had gotten so high that homeowners could no longer stay in their houses. So there was like a revolt, a pushback. And people said, no, enough's enough. And they passed Prop 13. So I don't know if it'll happen in my lifetime, but hopefully there will be another similar type Prop 13 revolt where the people that are left who are paying more and more taxes because other people are leaving saying, look, enough's enough. We have to turn this around and go the other direction.
Man, I really hope this does happen, because I do know a lot of my friends who were business owners, and they did leave. They did go to Texas, Florida, and Idaho, and they're so much happier. They're keeping home a lot more money. They don't have to pay the crazy state tax anymore. And the thing is, we all love California.
It's hard not to like California.
It's hard not to like California.
Especially if you grow up in San Diego, yeah.
Yeah, I grew up in San Diego. I lived in Texas for a year, but it was cool. But nothing beats home, especially San Diego. San Diego used to be, I used to think when growing up, before it really blew up, I was like, I can't believe everyone wants to move to LA. San Diego's the greatest city in the country that no one knows about. And somehow in the last few years, everyone found out about it.
No, it's so true. Especially, okay, people are complaining about California just growing up in San Diego like I did in the 50s and 60s. Like even LA, that was a big deal. Like I went to undergrad school up at USC, fight on. And I remember the first day I got up there, it's in downtown LA, and how smoggy it was. And when I walked to class, how my tears were coming down my cheeks because of the smog burn so bad.
Oh, wow.
And so, I mean, San Diego, especially in the 50s and 60s, was just this incredibly easy place to live. Like, people wondered, why did you want to go to school in LA? And I just wanted to go somewhere different. But, and so even San Diego's changed a lot, but then California itself, overall, it's just a much more difficult place to live.
Do you have any tips for small businesses such as like myself and a lot of small businesses here in California specifically on things they should avoid when hiring employees? A lot of people are scared to hire employees right now. They want to hire private contractors because they don't want to.
Well, the problem with, my advice is don't have employees, make them all contractors, but the people that run the state figured that out. Now they've made it much, much more difficult to classify employees as independent contractors. I think the best idea, and it's probably the most economical, is to join employer organizations like the California Chamber of Commerce. They have really, really good resources for an employer that has the same questions you do about hiring people, about wage and hour laws, and that's a tremendous resource that's very, very relatively inexpensive. Or there's another group called SHRM for HR professionals. There's tremendous resources that those organizations have in terms of for small businesses, especially the Chamber of Commerce. That's kind of what they're set up to do. And they have, like I say, they have seminars constantly. They have, websites you can go on or blogs that contain all this information. So I think I would join if we're actually going to be an employer and retain the services of people, because now this who's an independent contractor and who's not has been a major issue since they passed what was called AB 5 back in, I think it was 2019.
I remember.
So, all those are things that you need to be aware of. Like, how do you classify someone as an independent contractor versus an employee, which, like I say, is after AB5 much harder to do. So those are the sorts of things I would be aware of, and I would go to groups like that. So you don't have to hire an attorney. Attorneys are expensive. You want to avoid that. But if you can, those groups have tremendous resources. I would strongly recommend organizations like that.
Also, do you have any tips on what are maybe the 3 most common lawsuits employees sue their employers for?
Wage and hour leads the pack way beyond everybody else, because I mean the labor codes are hard to deal with, and the penalties are so great, and the attorney fees incentive for attorneys to represent employees. I mean, there's just constant wage and hour lawsuits. So that'd be number 1. And then behind that, retaliation claims are common.
What is
well, let me
give me an
explain
example
what that
of a
is.
retaliation
Okay.
is.
So let's say you think you were discriminated against for your age, and you complain about that, and your employer, and even though you weren't discriminated against, your employer fires you because you complained. Well, firing someone because they complained just creates as much liability as firing them for what they complained about. So I would say number 2 would be the retaliation claims. The sex harassment claims, those kind of peaked out. You still get those, but employers have really cleaned up their act. I mean, there's so much publicity about that, and employers are so much more aware of that now. You really don't see, you still see those, but not as many as you used to see. In the 80s and 90s, that was a cottage industry, because that's when the law started to change, and employers just, there were workplace practices that went on that just now are not permitted, but at the time that was occurring. So I think the 80s and the 90s, you saw more of that. So I would say 3rd, probably age discrimination. Because people like me are, we're still working, but we're old and we aren't as good technologically as the kids. So a lot of employers simply want younger employees because the workplace now is so technologically advanced that that's just, that's a requirement that you really have to be savvy at that. So older workers tend to get replaced, like me. So I have a legal assistant in her 20s who went to UCSD, very tech savvy. I couldn't operate without her. She runs the show. And so, but that's true in most workplaces. And so older employers just didn't grow up, digitally like, kids do now. So I would say age discrimination might be 3. That's just my observation.
And let me allow me to play devil's advocate for a second. If you're an employer, and let's use age as a good example. You have somebody, they don't have to necessarily be old, but just somebody in general, probably older.
That's all right. Probably older, yeah.
But they sort of, they don't bring the value that a business needs. Like, let's say they're not tech savvy and all that stuff.
Well, okay.
Shouldn't the employer be like, hey, John, we really don't have a space for you. We're pretty much just paying you just to pay you, but you're not really helping us at all with the business.
No, an employer has a right to, you don't have to keep people just because they're old and they can't operate the computers. I mean, no, you can have what they call bona fide occupational qualifications. There's job requirements. If the older workers can't meet those simply because of their background, then that's unfortunate. But you can keep the younger people. You just have to be careful with that. Like, there have been cases where it's just cultural. Like, I don't like old people here. So the old people might be just as productive, but to some younger people, they just, they don't like older people around. So that's an example of that. And then, you find statements that people made, through emails and texts and things like that, where their true motivation wasn't the lack of productivity, but the fact that the person was older. And so, but you're absolutely right. Yeah, you don't have to keep someone older if if they can't perform as well as someone who happens to be younger.
And that made a lot of sense, what you said right there. It's not that they don't bring value to the company. It's just that they're literally being discriminated for being older or whatever, you know what I mean? So, and that shouldn't necessarily be allowed.
Yeah, no, okay, so age discrimination is discriminating against someone because of their age, not discriminating against them because they can't perform. If they can't perform, you don't have to keep them at any age. I mean, you can hire idiots that are 22.
It's true.
And so...
It's a lot of them.
Yeah, a lot of them, yeah. And so, sorry. No, and so, yeah, it's whether they can perform, yeah.
Playing devil's advocate one more time. Shouldn't a business be able, like it's your business. Let's say you do want a certain type of culture. You want this specific demographic to be work as employees, right? You want them to fit into this box. As somebody being in the free market, shouldn't you be allowed to be like, hey, if you don't fit in this box, we don't want you?
You can do that as long as the box doesn't exclude people based on their age, their race, their sex, doesn't exclude people because of protected categories. Mm-hmm. Now, as a practical matter, if certain types of work will probably attract a certain type of demographic of employee. And so, no, that's fine. You just can't exclude people based on what's a protected category. You can't say, okay, you're too old, we don't want you in that. But then, like I say, it's practicalities. I mean, someone my age probably wouldn't come down here and work in this type of a setup. It would be younger people like the ones I'm observing who are around here. So yeah, you can do that. You just can't explicitly exclude someone, because of their age, their race, their sex, their sexual orientation, etc.
Do you have any? I'm sure you do, and hopefully you can tell an amazing story over your years of doing law. You don't have to get into specific details that'll get you in trouble. But could you give us a story on one of the cases that you worked on?
Really, and I don't mean to make light of sexual harassment, but this was an interesting case where a company was based in LA, Beverly Hills, family-owned business, and they had operations in San Diego. So family business, they sent the son right out of college down to run the business. The son was, lack of a better term, quite a Romeo, and began dating several of the employees who worked in the business. All was okay, everything was consensual, until the ladies he were dating all seemed to somehow have got together and figured out that the son was dating all of them, yeah. And so became pretty upset about it. And what was an entirely consensual relationships then turned into allegations of sex harassment. Oh, wow. Even though by, I think, any fair evaluation of it, there was nothing non-consensual about it. And so they hired a smart plaintiff lawyer, yeah. So he wrote this demand letter, and basically to the company up in LA. Dad reads that and like, geez, man, what's going on down there, son? And so eventually they settled it. But it was just interesting because of everything was okay, and then the people got together, they became upset about it, and then which shows why dating relationships in the workplace, probably not a good idea. Definitely not a good idea if it's the person in charge dating, subordinate people. So I thought that case always stuck with me. A lot of interesting cases out in Imperial Valley when I lived out there. because of the workforce, primarily lives in Mexico, but then they commute to the United States. And just a lot of different issues, and the travel, the commuting back and forth, extremely hardworking people, the farm workers are. And so, but there were just different issues that would come out of that. And that's kind of Imperial Valley is kind of a unique environment. And so, and just in terms of the history and the employer-employee relationships out there. So that, the Valley was a really interesting place to practice for a couple of years right out of law school.
Wow, that's interesting. Going back to the Romeo story, it reminds me of the age-old saying, do not shit where you eat.
That's true. That's true. And so, and I'm certainly not trying to make light of sex harassment cases where there's an employer-subordinate and inferior relationship and someone's compelled to have a relationship. But this was nothing like that. I mean, it was, I investigated it really closely.
Right.
And there was simply, and I told the dad, I go, look, there's no harassment here. Just the ladies got mad and hired a plaintiff lawyer, and you're going to pay for it. So unfortunately, the son had to go back to L.A. And so this was probably about 30 years ago. It was a long time ago, but I always remember that case.
Yeah, that's a good example where, like, when you work with people closely, especially when you're the boss, there's going to be a natural attraction.
I know, and so that's the problem in this area, is that if you think, where do you spend most of your time?
At work.
Yeah,
you don't spend relationships.
You don't spend it in singles bars. I mean, looking for relationships or on dating apps, you spend it at work, and you're apt to, and you're working in an environment where there's other like-minded people who have similar interests, or you wouldn't be working there. So it's just sort of this natural attraction, and common sense would tell you that, okay, people in the workforce are going to date, and this is going to be an issue. So what a lot of employers have done about that, and we certainly advise them, a lot of times is to have disclosure requirements in a handbook. If you're going to date someone at work, we want you to disclose that. If you're going to date a subordinate and you're a supervisor, you can't be in the same department. And then generally that's discouraged anyway. So employers tend to discourage these relationships, but common sense will tell you that they're going to occur. So.
Yeah, it's only human nature, but like you said, it's you're playing with fire when you do that, and you don't even have to be the boss. You could just be an employee dating
right,
your
because
coworker.
people are much more sensitive about that now. So
feelings get hurt.
Right,
and then it becomes a toxic atmosphere.
Right. No, and everything gets blown out of proportion. And it's just in this environment that's very, very difficult, not well advised. Exactly.
Talking about that real quick. So these I'm gonna play devil's advocate again,
sure.
Right?
That's what we do.
So. It's human nature, right, is to be attracted to the opposite gender, but it would be discrimination because this is going to happen, and this happens all the time in almost every business. But it would be discriminatory to be like, this is going to be like, let's say all the females work on this side, all the males work on this side,
yeah.
Or we just don't want to hire women because this usually happens, or I don't even want to hire men, only women. You can't do that either. So
there's really your analogy about the box. Can I get the people in the box I want? Yes, you can, but you can't exclude people who, because of their age, their race, their sex, or whatever.
So then what happens is these are just unavoidable,
right?
Because human nature is going to do what human nature does. Do you have any advice for an up-and-coming attorney who wants to get into employment law, defending the employer side? What kind of advice would you give them?
Well, there's a couple things. So it's probably easier to get in this area representing employees because there's always employees looking for someone to sue someone. Most employer side work is usually for larger law firms, or not just usually for an established law firm. So I would look for that. I wouldn't I wouldn't restrict yourself to San Diego. In other words, if you go to law school here in San Diego and you want to do this kind of work and you can't get a job at, say, a firm that does that, then be willing to go somewhere else. You got to be flexible. And then if you keep working at it, then eventually, and if you want to come back to San Diego and you get experience, you can. I mean, that's, when I came out and ended up in Imperial Valley, my wife and I both grew up in San Diego. We definitely didn't want to stay there, her in particular. And so, but eventually, we worked our way back, and it turned out okay.
So there you have it. Don't be scared to move out of San Diego. And as a young entrepreneur, you should want to leave the nest anyways. You should want to go test the waters in other places, experience other places in the country, and then here's why that's a benefit as well. When you leave San Diego, for some reason I'm speaking to all the San Diegans right now. When you leave San Diego, it makes you appreciate San Diego much more.
Especially El Centro, yeah.
Yeah.
And I don't want to speak ill of El Centro. No, but we lived out there for 2 years, and it was different, and so.
Right. Well, I remember when I was growing up here in San Diego, I didn't really appreciate San Diego. I knew it was beautiful, but it's all I known, and I just always felt like trapped. Like I was like, I got the mountains to the east, the border to the south, the water to the west, right? You got LA up north. San Diego didn't really feel special. It just felt like a bubble. And it wasn't until I moved to Texas for a year and I really experienced something outside of San Diego. And Texas only really has like 2 seasons where it feels like San Diego, how San Diego feels all year round. And when I came back to San Diego, I really appreciate where I live so much more.
No, that's true. And having gone away to college and then even out of law school, moved away for a while, and then coming back, we like it here and been here for a long time now. So been back for a long time. So.
Well, Scott, I appreciate you for coming in.
Okay, Jeremiah, anytime.
Thank you, man.